Good afternoon. My name is Emily Sumner. I am an immigration attorney with Sumner Immigration Law based in Richmond, Virginia, serving clients throughout Virginia, the United States, and all over the world. Today, we're going to talk a bit about what U.S. immigration has been like since Biden took office and what to expect the second half of this year. If you could put in the chat that you can hear me okay, I would appreciate that before we get started. So an overview of topics, what we're going to be talking about today. First, we're going to be talking about what we've seen in terms of trends and changes in terms of non-immigrant visa processing. Then we'll move on to green card processing, which is also known as immigrant visa processing. And then we'll talk about what is on the horizon. So non-immigrant visas. Non-immigrant visas are temporary visa classifications. So when we talk about non-immigrants, we're talking about H-1Bs, Ls, TNs, E-3s. For almost every letter of the alphabet, there's a different temporary visa classification. And that's what this is talking about. That's what non-immigrant refers to. The changes that we've seen since Biden took office, and I'll back up for a minute before I get into the details of the non-immigrant visas. When Biden took office, of course, I was very excited that Biden was taking office because, not to get political, but just hopefully, we are hopeful that things would change with immigration law. As you can imagine, for the past 4 years under the previous administration, things were challenging. There are a lot of challenges, a lot of changes in the way that green cards were processed, the way that immigration petitions were processed, a lot of delays, processing delays. So we were hopeful that things would change under the new administration. Things are changing, but it's going to take time for sure. It is not possible or realistic for things to change immediately overnight. We are seeing some culture changes in the agencies, and that's nice, but we're also dealing with delays that were created because of COVID, consular offices consulates being closed because of COVID and not reopening yet. So there are a number of things that we're still dealing with. There wasn't a light switch that was switched and immediately changed things for the better immediately. So that's something to keep in mind. We have to keep positive, keep optimistic, but recognize that things are not going to change immediately. And I recognize we're 6 months into the year already. We're seeing some positive changes, which we'll talk about, but there's also a long ways to go. So in terms of temporary visa classifications, such as H's, L's, TNs, all of the temporary visa classifications, what we're seeing, the trends that we've been seeing are continued processing times being extended, continued extended processing times. So in other words, it's taking a long time for USCIS to process petitions once we submit them to USCIS. It is nice that we have the option of using premium processing. Great, thank you for confirming that you can hear me. It's nice that we have the option of premium processing for certain visa classifications, such as the H and the L, but there are other visa classifications for which that's not a possibility, and it's $2,500. You don't necessarily want to spend that as an employer or as an employee on every petition that you file with USCIS. So for H-1Bs, we're seeing for processing time about 6 to 8 months, which isn't terrible. It could be better, definitely. The main, I would say, pain point of frustration that we're seeing with processing times is with the H-4s, with the dependents. So for the H-4s and the L-2s, and those are the spouses of the primary visa holders, so the spouses of the H-1B visa holders or the L-1 visa holders, the H-4 processing time is currently 10 to 13 months. What that means is, of course, it's going to take approximately 10 to 13 months for the petition or the application to be processed. That means that we are not able to place service requests if the application is still within that processing time. So by that, I mean, typically when a case is taking a long time, we want USCIS to take a look at it, speed up the processing. We will place online or by calling USCIS what's called a service request, but we are not able to place those service requests if the processing time is, or if the case is still within processing time. So that's a challenge, and we'll talk about that more later on in this webinar as well. But for H4s, it's taking a very long time. That's a problem primarily because the H4s need to extend their driver's licenses, and a lot of times or renew their driver's licenses. A lot of times they're not able to do that if their H4 application extension is still pending. Likewise, they are not able to get the EADs. A lot of times an H4 spouse is able to apply for a work permit or an employment authorization document, also called an EAD. Those processing times are dependent on the H4 extension or change of status or whatever it is being approved. So we said that that's 12 to 13 months. That means the H4 EAD is also going to take at least 10 to 13 months. That's very frustrating, especially because the EAD, once it expires, you can't use it anymore. There's no automatic temporary extension like there is sometimes for other types of EADs and other instances. So that's very, very frustrating for lots and lots of people. How to follow up and when? You can follow up with USCIS, like I said, once the case is outside of processing times. However, if it's within processing times, USCIS, when I say within processing times, I mean, we look online at the USCIS website to see what their processing time says for this particular type of case that you filed in the service center where it's pending. And if it is still within processing times, still within what USCIS says is regular processing times, they will not allow us to place a service request. That means that your options are either to possibly seek congressional intervention, or in certain instances to sue if it's an extraordinary delay, to sue the government. We do not handle litigation. We don't handle lawsuits and federal court, but if anybody's ever interested in that, we can, depending on the situation, we can refer you to someone who does handle that. As far as congressional intervention goes, we really try to reserve that for life and death situations. Obviously, they have limited capacity to follow up with USCIS or different government agencies. And lots of people are seeking assistance right now. So we do try to limit that to situations that are really dire situations. But all that being said, I know it is so hard to be patient, especially when you have so many things hinging. It's not just that you want it approved just to have it approved, but there's so many things that are hinging on this. So I totally get it. Between your driver's license, your ability to work, possibly your ability to change jobs. I know that there's a lot, your source of income, there's a lot hinging on it. So we really are empathetic to clients who are stuck in the situation of waiting for the government to approve, but that's where we are right now. Good news is there are no more biometrics, at least for the next 2 years, for H2 and L2 applicants. So if you're applying for a change of status or an extension for the H4 or the L2, then you no longer have to have the fingerprinting done. That means you do not have to pay the $85 biometrics fee, and you don't have to have the fingerprinting done. That's huge because that was, USCIS said, a primary reason or one of the reasons for the delay in processing the H4s and the L2s. They had to, of course, schedule the biometrics, then COVID hit. So the USCIS was closed for a number of months, and then they have a backlog to work through. And just in general, they have so many to schedule that it takes several months to schedule these biometrics. And they weren't able to apply to approve the H4 and then subsequently the H4 EAD until the biometrics were done. This change came about because of a lawsuit. So there were a group of people, several different litigants, plaintiffs who sued USCIS saying that that is not within the regulations, not within the statute rather. It was not necessary, and USCIS has agreed through that litigation for a period of at least 2 years to suspend the biometrics requirements. So it's not necessarily going away forever, but for at least the next 2 years. That's nice that we don't have to worry about that. The deference memo is another good piece of news. That means that there was a USCIS memo that was in place before the Trump administration that basically said that USCIS, if you're filing an extension of the same petition, let's say an H-1B petition or an L petition or a TN, any number of different classifications, if you're filing an extension and there's not a significant change in the circumstances, USCIS should defer to the previous approval, unless they find that there is gross USCIS error, if they decide that they approved it in error previously. During the Trump administration, they rescinded that memo. They said, nope, we're adjudicating everything anew from the first time going forward, as if it were the first time that you were filing. And so that's been flip-flopped again. And now the deference memo is in place again, meaning USCIS should defer to the previous approval. That does not mean that it's a guarantee that your case will be approved by any means. I definitely recommend that when people file petitions, they file it with as much documentation as they can. Make sure it's well documented, well prepared, well organized. You don't want to just rely on that memo and assume it's going to be approved, but that's good news. It's a step in the right direction for sure. And then finally, about 11:45, about 15 or 20 minutes ago, well, a little bit more than that, but 11:45, just before this webinar, we received an email from USCIS saying that they are rescinding the RFE and NOID. That stands for Request for Evidence and Notice of Intent to Deny memo, which came out during the Trump administration. That memo said, if you don't submit the initial evidence with your filing, then we can deny the petition or application right away. They are rescinding that memo, which again came out during the Trump administration. And they're saying, hey, if you didn't submit the initial documentation that we need, then we're going to issue a request for evidence or notice of intent to deny instead of immediately issuing a denial. So that's great. It provides a little bit more flexibility and is a little bit more forgiving than the previous policy. So those are steps in the right direction, but again, USCIS is struggling with the processing times. Another area that we're seeing some challenges right now is, of course, with travel, and this is because of COVID. There are a number of COVID-related travel restrictions. Of course, there are travel restrictions for visiting other countries, but what I'm talking about is the travel restrictions for certain foreign nationals entering the United States. So if you plan to travel this summer or anytime, while COVID is still a thing, which it probably will be for the foreseeable future, make sure that you have checked the travel restrictions, COVID-related travel restrictions. The good news is the port of entry, the border between Canada and the United States, is at the point of reopening, at least more so than it has in the past. So that's excellent news. However, there are still what I'm calling travel bans in place. That means that if you were entering the United States from the UK, from Europe, or most of Europe, the China, Brazil, South Africa, there is a travel ban in place, COVID related, that says you cannot enter those countries if you have been, or you can't enter the United States rather, if you have been in one of those countries for the previous 14 days. That means that if you are, let's say, going to enter the United States from India, that you have to spend those at least 14 days in another country, not India and not the United States, before you enter the United States. So there are ways to overcome it, but it's definitely a challenge in this environment. The Trump travel bans have been rescinded. So Trump, you may remember, in April and June of 2020, so about a year ago, implemented 2 specific travel bans that applied not to countries, but just in general to immigrants, immigrant visas, meaning people entering the United States on a visa that would allow them to get the green card once they enter the United States. And then subsequently, there was a ban that applied to individuals entering on certain temporary visas, including the H and the L. So those travel bans were rescinded, which is fantastic. So there's a lot of changing moving parts and changing requirements. So keep in mind that there are still COVID-related travel restrictions, but they're limited to specific countries or areas. They're not specific to your immigration status and apply worldwide, which is nice. In addition, with the COVID-related travel bans, keep in mind that there are exceptions. For example, if you are the parent of or spouse of a U.S. citizen, if you're a parent of a U.S. citizen minor child, it has to be a minor child, it can't be an adult child, then there are certain other exceptions as well. There are other exceptions as well. So make sure that you check that. You can always contact us if you have questions about any upcoming travel and whether you would be exempt. In addition, there's the possibility of applying for what's called a national interest exception, meaning you have to meet certain criteria which are changing seemingly week by week with Department of State. But it is possible to apply for a national interest exception as well if you're not able to quarantine basically for 14 days in another country before you enter from one of these restricted countries. Another challenge that we're seeing right now and kind of trend that we're seeing right now is with consular operations. Consulates around the world have been closed for the past year plus, since March or possibly even February 2020, depending where in the world it was, or where in the world we're talking about. So that's really, really challenging because people are not able to, foreign nationals wanting to enter the United States, either as immigrants, meaning once they enter the US, they would receive their green card if they've gone through a certain process. So people wanting to enter as immigrants or just get the temporary visa stamped, whether it's a visitor's visa or an H-1B or a TN, or an L, any of these temporary visa classifications, the consulates just are not open to accept people to have these visas stamped. That's tremendously frustrating. It's a tremendous challenge for our clients. And again, we're very empathetic to that. We are working with clients and trying to help them identify alternative options to the extent that there are. Sometimes there just are not options. However, these are the options. So as I said, consulates are either closed or working at a very reduced capacity. Some consulates will accept an emergency appointment. Those, as you can imagine, are difficult to get. We have found in some instances it's helpful to have congressional intervention. Again, we're trying to limit that to situations where there's a life or death situation, not, I don't want to say just, because I know it's important to see your family, but not situations where you want to go attend your cousin's wedding. It'd be great to be there, but that's probably not appropriate for congressional intervention. But congressional intervention is a possibility. We have several clients who have applied for the I-485, and so they are able to, which is part of the green card process. If you have an advanced parole document approved, which is what that AP, that abbreviation AP stands for, it's possible in some circumstances to enter the United States on the AP. There is a visa interview waiver program available, and Department of State has extended or expanded rather the requirements for that to make it a bit easier for people, because they know that the consulates are closed or working at reduced capacities. So that's fantastic news. That may be a possibility as well. You do have to meet certain requirements. You definitely should check those requirements before you leave the United States to make sure you don't get stuck outside of the United States. But my point, and then the national interest exception is a possibility as well. So my point is, it's very difficult these days to travel. However, it's not impossible. If you are one of our clients and you plan to travel, please contact us. Let us know what questions you have. We want to make sure that you have a solid plan for being able to come back to the United States and that you don't inadvertently get stuck in wherever you're visiting while all this is happening with COVID. If you are not one of our clients, feel free to set up a consultation with us, and we're happy to help assess your situation, help you walk through the process. So one thing I did not say before we began here is, if you have questions as we go through this or at the end, please feel free to put those questions in the chat here, and I'm happy to answer them. I have based this presentation on the questions that you all submitted with the registration, and that was very helpful to know what you all are interested in hearing about. But if you have other questions that come up or that we're not addressing, feel free to put them in the chat. We cannot answer fact-specific questions, but if they're general questions, we're happy to try to address those. So we're shifting now to the green card process, or the green card context environment. We've been talking previously about the temporary visa classifications. With green cards, very, very good news. On March 9th, USCIS announced that they would get rid of or rescind the Form I-944, which was related to public charge. If you have been involved at all previously, I'd say in all of 2020 with the green card process, you probably know that there was an additional form that was about 15 pages long. It might have been 18 pages, I can't remember now. But it was a long form, 15 to 18 pages, that required lots and lots of information about the green card applicant's financial information, including their source of income, their liabilities, meaning debt, their credit score, information about their education and career opportunities here in the United States, and English language skills, all kinds of documentation, which of course required hundreds of pages of additional supporting documentation as well. So it was a significant challenge sometimes to gather all this documentation and submit it. So we were thrilled when it was announced that that is no longer a requirement. We're thrilled about that. That's a positive change that has come about with the Biden administration, and one that we are really hoping for. So that's fantastic. On the other hand, the trends that we're seeing are, again, with processing times. Like I said, in the non-immigrant visa process or context, we're seeing the same challenges in the employment-based, or the green card-based, not necessarily limited to employment-based, but in the green card context, we're seeing the same thing. So just to give you an idea about estimated current processing times, and these are all estimated, for the perm labor certification, which is the first step in the employment-based green card process, that is taking about 6 to 7 months to be certified. So there are months worth of preparatory steps that you have to take ahead of time before you submit it. But once you submit it to Department of Labor, if the case is not audited, it's taking about 6 to 7 months for Department of Labor to process that. The I-140 petition is taking about, I would say, 6 to 10 months. That's a big range, but about 6 to 10 months. And the I-45 is taking at least a year to year and a half to process. USCIS processing time, if you look online, says that it's taking 10 to 30 months. That's 10 to 30 months, which is an extraordinarily long time for the I-45 processing. So if you're in one of these processes, know that you're probably in for the long haul, that it's going to take some patience. It's a lot to deal with, for sure. But it's good to go into the process with a clear understanding of what the anticipated timelines are. And we try to let our clients know as that changes over time, because we do think it's important for everyone to have clear expectations of what to expect going forward. Keep in mind with the I-485 processing, I said that the processing times are 10 to 30 months, and it varies depending on which service center, where it is, and that's not something we have control over. Clients have asked that sometimes, can you please file it with the X service center because they have better adjudication or better processing time or whatever it is, and that's not something that we can choose. It just depends on where you live, and then we have to file it with X service center. But with the I-45 processing time, the priority date has to be current before it's approved. So let's say that you reach the 30-month processing time. It's been pending for 30 months. I hope that nobody's in that situation, but it's possible. Well, if the priority date has retrogressed, then it's going to not be approved yet. You have to wait for the priority date to be approved. So keep that in mind, that with the I-45, you're looking at processing times, but also is your priority date current? And we'll talk a bit more about that in a minute. We have a question about the time frame for the I-140 processing. It's about, I would say, 6 to 10 months. And that's without premium processing. It is possible to apply for premium processing with the I-140 petition, and we'll talk about that more just in a minute. But if you submit an I-140 through premium processing, they have 15 calendar days to issue a request for evidence or approve the petition. And all of those timeframes are from USCIS, from the USCIS website. It does vary by service center, but those are kind of the averages, and it changes all the time. So those are not written in stone by any means. So what trends are we seeing with the Biden administration for green cards? Great news. In addition to the I-944 being rescinded, the public charge rule being rescinded, we're seeing, and this is not an official, there's been no official announcement, this is not official, but this is what we're seeing on the ground, if you will, that employment-based interviews are being waived. That means that it used to be during the Trump administration that so let me back up for a minute. It always is a possibility for an interview to be required for the employment-based green card, especially if a person has an interesting immigration history, or if they have a criminal history, then an interview always, from the beginning of time, may have been required. During the Trump administration, they made it mandatory for all employment-based cases to have an interview. So that, of course, slowed down processing times because USCIS had to schedule and conduct interviews for all these people. We're seeing that that's being waived, which is fantastic. It's allowing green cards to be approved faster because they don't have to wait for the interview to be scheduled. So that's excellent news. With immigrant visa processing and K-1 visa processing, these are related. These processes go through the consulate, U.S. consulates overseas. So again, immigrant visa processing is when, let's say, an employer sponsors you for permanent residence, but you're overseas, or a family member sponsors you for a green card, but you're overseas. You would apply once you've gone through the preliminary steps. You would apply for what's called an immigrant visa at the U.S. consulate. That does require an interview, whether it's employment-based or family-based. It requires an interview at the U.S. consulate in your home country. And that interview those interviews are not being scheduled quickly. It really varies depending on which particular consulate, but most of the consulates are not working at full capacity. Department of State keeps putting out statements saying that they're prioritizing immigrant visa interviews, especially for immediate relatives, which is fantastic. But we're really seeing a lot of inconsistencies among the consulates in terms of how quickly interviews are being scheduled. And the same thing is true for the K-1 interviews. Department of State, K-1 is the visa for a fiance, so a fiance of a U.S. citizen. So if you're not married yet, but you're coming to the United States for the purpose of getting married, a lot of times a person will come on the K-1. That's the appropriate visa, the K-1 visa. It's also called the 90-day visa because you have to, the K-1, a person who enters on the K-1 has to stay in the United States, or not stay. They have to get married within 90 days of entering the United States. So that's where the 90-day fiance visa comes from. Anyway, the K-1 interviews also are being scheduled very inconsistently. It is taking a very, very long time for these interviews to be scheduled. In some cases, we're not seeing them be scheduled at all. We keep pushing with the NVC, contacting the consulate back and forth. We're encouraging clients in some situations, again, to use congressional liaison when it's appropriate. It's a difficult situation. We have a question I did not understand about I-45 processing time, how it's related with priority date current. So I was just saying that your priority date has to be current in order for USCIS to approve the I-45. So in other words, if your I-45 is out of processing time, if you look at the USCIS processing times and you say, oh my gosh, it's outside of processing times, you have to also look and make sure that your priority date is current. If your priority date is current, then and your I-45 is pending, then we recommend that you contact, or if you're our client, we will for you, contacting USCIS just to make sure that they remember they're supposed to do sweeps of the files to make sure that they pull I-45 files where the date is current. When I say the date is current, it has to be current per the final action date, not per the dates for filing. But if it's current per the final action date, we are proactively contacting USCIS to say, it's current this month, please adjudicate this. And a lot of times that works, not always, but most of the time that works. So what we're seeing with the I-45s, I'm talking specifically, it's not limited. I was going to say talking specifically about the employment-based, but all this applies to the family-based I-45s as well. So again, the I-45 is the application for permanent residence. You can't just submit an I-45. You have to take preliminary steps before, depending on whether your employer is sponsoring you for a green card or a family member. But the I-45 is the actual green card application, and it's filed here in the United States, assuming that you are in the United States in valid status in most instances. So what we're seeing after filing the I-45 is biometrics delays all over the place. If you have not received your biometrics yet, you are not alone. That's, again, something we're trying to push USCIS on, but it is next to impossible. We're tracking that for clients and making sure that people who filed, for example, in October of 2020, when a lot of people were eligible to file, have had their biometrics done, and we follow up with USCIS and get no response. It's tremendously frustrating. I think they said in December they were 1.3 million finger biometrics appointments behind. So that gives you an idea of how much they have to catch up on. I think that's a combination of USCIS being closed because of COVID for about 3 or 4 months last year. And then just the sheer volume. There were so many people who were able to apply in October of 2020 that there are a lot of fingerprint appointments to get through. And then you add to that the biometrics appointments for everybody else, for the H4s and L2s that were previously required. So it's a lot to get through. I'm not justifying it or saying, oh, that's okay, USCIS, but they have a lot to get through. My point is, the takeaway here is, if you have not had biometrics scheduled yet, it is not unusual. I would say if it's been more than 6 months since you have filed the I-485, at that point we can follow up. But until then, I think it's kind of a lost cause. EAD processing, we're seeing very inconsistent processing times for the work permit or employment authorization document after you submit the I-485. Sometimes clients will get that within 2 months. Other times it's been pending for 10, 12 months and people still haven't received it. One note, again, this news just came out at about 11:45, about 15 minutes before we started this webinar. USCIS has announced that for EADs, employment authorization documents based on the I-485 filing for initial and renewal, not replacement, but initial and renewal EADs, they will make those valid for 2 years. And they say in that announcement, yes, processing time is approaching or exceeding 1 year for I-485s. I wish that their solution was, we're going to speed up the I-485 processing so you don't have this problem. That's not what's happening. That's not within our control. So at least it's good news that they're making the EADs valid for 2 years so that people won't have to, the initial and the extension valid for 2 years. So that you won't have to renew once a year, but it's a journey, it's a challenge. The effective premium processing, and here I'm talking about premium processing the I-140 petition. It is not possible to premium process the I-485. The I-140 petition is, of course, the second step in the employment-based green card process. It is possible to file the I-140 petition and premium processing in some instances. I say here it may not be possible because if you filed an EB3 downgrade, so in other words, if you previously filed an I-140 petition with the original labor certification with USCIS, like let's say years ago, then you subsequently file a second I-140 petition with a copy of the labor certification. A lot of times when we try to file a premium processing upgrade, that is when we request premium processing with USCIS, USCIS is saying, we don't have the original labor certification on file, so we can't process that in premium processing. And a lot of times if we file about a month later, then it's accepted, but not always. We have a couple of cases where we have tried multiple times and USCIS keeps saying we don't have it, which is interesting because the original labor certification was filed with the same office where we're filing those premium processing upgrades and the downgrades. So it may be that they it was done so long ago that they moved the file with the original labor certification off site. And so they don't have it, or maybe they can't find it. I don't know what the situation is. It's frustrating, but just know if you try to upgrade your I-140 petition to premium processing, it may not be accepted. The effect of premium processing is, of course, you have your I-140 petition approved, which it has to be approved before the I-485 is approved. So if you think your priority date is going to become current per the final action date in the next few months, it may be a good idea to try to upgrade the I-140 to premium processing. However, upgrading to premium processing has no effect on the employment authorization document or on the travel document, the approval of those two things. So it's totally separate. Just because you upgrade to premium processing does not mean that they will then immediately or soon after approve the employment authorization document and the advanced parole document or the travel document. Good news, to wrap up this particular page or this slide with good news, we are seeing movement. We've had a couple of clients, even in the past week, who have received the I-485 approvals. They have their green cards. It's an employment-based process, and they have waited years, like almost as long as I've been practicing, which is 16 years. For the green card. So that's great that USCIS is moving. So what's coming next? This is what's on the horizon. Dates are progressing. By that, I mean priority dates. And I mean that in the family-based context and also in the employment-based context. So if you follow Charlie Oppenheim, he's what I call the man behind the curtain with Department of State, who gathers data from USCIS and Department of State and then publishes the visa bulletin once a month. If you follow him, you'll know that dates are progressing, and that he anticipates that the dates will continue to move forward aggressively through the rest of this year, or this fiscal year, which ends September 30th, and then towards the beginning of the following fiscal year, which starts October 1st. USCIS says that they are pre-working cases that are ready to be approved. We'll talk more about that in a minute on the next slide. There's no insight yet on what's going to happen in October 2021. No one can tell you what the visa bulletin dates, including Charlie, who's in charge of the whole thing. No one can tell you what the dates are going to be in October 2021. I have lots of people emailing and saying, my date is this date in 2015 or 2016, and it's going to be current. Can we get everything ready? And my answer is, yes, you can get documents ready. We'll talk about that in a minute. But we have no idea what the dates are going to be. No one can predict that with any accuracy. So I remain hopeful, I remain optimistic, but I'm not sure that we're gonna get to 2015 or 2016. I would love to be wrong. Also keep in mind, you have to have an approved PERM, labor certification, to file the I-140 and or the I-45. In October of 2020, we had a couple of situations where prospective clients approached us and said, hey, I'm ready to file the I-45, but their labor certification had been approved with employer A that they worked with 10 years ago. And they did not have a labor and had no intention of returning to that employer. And they did not have an approved labor certification with their current employer, the one they intend to stay with for the foreseeable future. So if you are in that situation where you're working for, let's say, employer D, for 3 or 4 employers into your career or into your time in the US, make sure you have a labor certification approved with that employer, and hopefully an I-140 petition either approved or filed at least with that particular employer. Again, it is not enough to have a labor certification approved from 10 years ago for an employer you have no intention of returning to. So make sure you're in a good situation to move forward as soon as your date becomes current. We had a question, an excellent question on one of the submissions, one of the registrations that says, what happens to unused numbers? If you don't understand what I'm talking about here, don't worry about it. It's really complicated. It has nothing to do with your intelligence at all, but don't worry about it. But for those of you who do follow the intricacies of the visa bulletin, I'm going to give you this information. There is a limit, as you may know, of 140,000 employment-based green cards available every year. That's in the statute, the immigration statute. About 120,000 unused, there are about 120,000 unused family-based green cards from the last fiscal year that rolled into the employment-based categories for this current fiscal year 2021. And those green cards should go to the individuals with the oldest priority dates. So in other words, and the reason we had those unused numbers is because primarily because consulates were closed and they weren't able to issue green cards that they otherwise would have issued. So there were a whole bunch of extra family-based, 120,000 extra family-based green cards. They rolled over to the employment-based categories. However, what's happening now? Those green cards, those extra 120,000 green cards have to be used, again, this is by statute, they have to be used by September 30th of 2011. 2021, wrong year, September 30th, 2021. Otherwise, and again, this is by statute, otherwise they go back for the next fiscal year, which starts October 1st, they go back to the family-based category, and would basically go unused because of the way that the statute is written. So basically they would be lost. What's happening right now is that USCIS, according to their data that's publicly available, they are not on track right now. So right now is June. Their fiscal year ends in a mere 3.5 months at the end of September. They are not on track to even adjudicate 140,000 applications worth to use up the full statutory number, much less the 120,000 rollovers that they have. So it's very, very likely that the unused numbers will be lost because they'll be rolled back to the family-based cases or the family-based categories, but because of the way the statute's written, they'll basically go unused. So bottom line is USCIS is not adjudicating cases fast enough to use up all of the allocated green cards, and they probably will be lost. That is not fantastic news, but that's where we stand right now. Bonus tip, if your priority date, let's say you have not filed the I-45 yet, if your priority date is not yet current, but you think it will be current soon, or even if you don't think it will be current soon, even if you think it's going to be another couple of years, get everything ready. Have everything organized in a Google Drive or in a Dropbox, so that the minute your priority date is ready, you can email those documents off to us or to whoever your immigration attorney is. So those are documents like your birth certificate, and I'm not talking about original documents. You would not need original documents unless you had an interview, just copies of them, scanned copies are fine. So things like your birth certificate, your marriage certificate, your divorce or death certificate if you've been previously married, not your death certificate, but your spouse's, deceased spouse's death certificate, obviously. A copy of your current and previous passports, your current and previous immigration approvals. So for example, your I-20s, your I-797s, your H-1B approvals, your I-94s, copies of your tax returns, your W-2s, your current pay stubs. Your medical exam, I would not obtain your medical exam now, because if you obtain your medical exam before you file the I-45, it's valid only for 60 days. If you have already filed your I-45 and you have not yet submitted your medical exam, you could go ahead and get it. I recommend not sending it in until you receive a request for evidence, because otherwise it won't be matched to the file. But if you have not filed the I-45 yet, the medical exam is one thing I would hold off on. But everything else, you can get it ready and have it organized so that, again, as soon as your priority date is ready, send it off to us or whoever your immigration lawyer is, and we can get everything started. So that is the information for today. Again, if you have any questions, please put them in the chat and I'm happy to help. Other ways to stay updated, there are changes almost every single day in immigration law, even in this administration, maybe especially in this administration, although it's been like that for my whole practice. There are always changes, which makes things exciting and fun to stay on top of. So ways to stay updated, read our blog posts, which are on our website. Join our email newsletter. We send the email newsletter once a month. You can sign up on our homepage, and RSVP to future webinars. We're going to start having the webinars quarterly. The next one will be in September, and we're going to start doing more videos, shorter videos that will be uploaded to our YouTube channel and social media, and you can check us out there. I hope you all have found this information helpful. Again, if you have questions, feel free to contact us. Otherwise, I hope you have a great rest of the afternoon. Thank you.